welcome back. How are you feeling? I don't know. How was the lunch? Okay. Okay. Now it's a we have a very known person. It's a great pleasure for me to introduce today a good expert, Mr. Pranav Bhat. So about Pranav Bhat, his association with numerous organizations nationally and internationally reflects his passion in IPR. One of his major contribution was featured in Shark Tank as well. He has further presented a lot of publications and paper in various national and international forum. So we welcome you, sir. Over to you.
Um, Very good afternoon to everybody. So whenever you hear a lawyer is going to come and talk to you, you expect a person in the mid-40s with gray hair, right? So this is not the typical case that you're seeing today. So I have been practicing IP for past 5 years, okay? And I completed my engineering. Then I got job in a company called Sagacious IP. And I was an electronics engineer. I thought IP stands for Internet Protocol, which means it's a communication company. Then when I got the interview and when I joined, when I see the offer letter, I saw that Sagacious IP stands for Sagacious Intellectual Property. I was not even aware about what intellectual property is. So this is how I got introduced into the world of IP. Then I was going through multiple projects. Then I slowly realized that, okay, God had different plans for me. And this is where I'm supposed to spend next 40 years of my career in this field. So, I'm currently working as IP strategist for a company called Lightspeed Photonics. It's a Singapore-based company. We design different types of semiconductor products. So let me continue. Fine. The first question that I'm going to ask you is, what is IP? Okay. Everybody would have heard the word IP in current days because IP is a trend word or a buzzword, isn't it? So whenever we see or whenever we hear any dispute that is going on with respect to IP, we see that, okay, something big is going to happen, right? What is the recent conflict that happened maybe, let's say 6 months ago? It was with respect to a copyright infringement with respect to a very famous film. What is that? Kantara, isn't it? Thaikudam Bridge basically put a copyright infringement suit on the Varaha Rupam song. So this actually caused a lot of setback for the big industry of sandalwood, and the film that made name in each and nook and corner of this India and also outside the country had to face certain setbacks. Okay, so why did this happen? Okay, and what is that copyright? Why did that cause so much trouble? Okay, so the reason being, it's an intellectual property. Okay, so when I say intellectual property, is it only limited to copyrights? I was told that you are new to this field, so I'm talking and starting with respect to something that you all are aware about. Copyright is something that all of you would have heard, right? Because you are publishing papers. Whenever you go for a publication, they say that what is the plagiarism percentage, right? So if there is significant plagiarism, means there is a copyright problem, correct? Fine. So in order to tell or put in simple words what an IP is intangible form of expressions. Okay. So there are two types of properties. One, you can touch and feel. I can touch and feel this chair. It's a tangible property. Okay. Can you touch and feel copyright? No. Right? It exists on a piece of paper. It doesn't mean I'm touching the piece of paper. It doesn't mean I'm touching the copyright. Okay. It's a intangible property. Okay. So all forms of IP are intangible properties. Okay. So I can easily put a worth on this chair. Okay, anybody can take a guess how much this chair would be worth? How much it might cost if I'm going to sell this? I mean, MAHE is not going to allow me. Apart from that, okay, let's say that I'm going to sell this chair. How much it would bring me? Let's say 1,000 rupees. Correct? Can you put a worth on a copyright on similar note? It's very difficult, isn't it? Correct? So that is what the power of intangible properties are. Okay? It may take valuation of a company from the basic investment that the company has made to its, let's say, 100 or 1,000 multiple of times. Okay, that's the power of IP. Okay, next slide. Okay, so today here I'm bringing about some simple types of IPs so that I will walk you through different types of IPs. Okay, whenever we hear an intellectual property and it needs to be, let's say, commercialized or made cash or made licensed, okay, we hear the word patents. How many of you heard the word patents? Okay, amazing. A lot of people have heard the word patent. So my question is, can I patent this mic? Yes or no? Yes or no? Fast. Okay, some people say it's not possible to patent this mic. Okay, so is it possible to patent this chair? No? Why? Why it's not possible? Because it's already known, right? It's already in the public domain. So whenever something exists in the public domain, it cannot be patented, right? So to say, what does a patent protect? What does a patent protect? Or for that matter, what does an IP protect? We understood that it protects some form of intangible expressions, correct? Yes, ideas, you are right. Yes, then what does a patent protect? See, every form of IP is protecting some sort of idea, isn't it? Some sort of intangible expressions, correct? Then why does there is a differentiation, patent, industrial designs, trademark, copyrights, and trade secrets? Why there's a differentiation? Because there is a purpose for every form of IP. Got it? Okay. Let's say that I created a different type of a microphone. Okay. Irrespective of where I keep, it is able to capture my voice. Let's assume. Okay. That type of microphone we are not aware about. Correct? Let's say I invent. Then I want to go for a patent. In that case, what does it protect? It protects. If I file for a patent, it protects the functionality, the functioning. Let's say a utility patent, a patent that protects utility. Okay? What does it protect? The functionality. Am I clear? Okay. Next, I have made the mic in such a way that it looks very unique when I see through my naked eyes. Okay? When I see through my naked eyes, it looks unique. In that case, I go for industrial design. Okay? Whatever I see and I presume that it looks different to my naked eyes. In that case, I file a industrial design. Okay? If I want to protect the functionality, what do I go for? Patents. If I want to protect how does it look like or its design, the external appearance, then I go for industrial design. Okay. Let's say that I have been selling this product for a while and there is a goodwill generated for my, let's say, the company which has been selling the product. Then isn't it necessary to protect the goodwill of the company? Correct? What if somebody copies my name and starts selling, let's say, substandard products in my company name? It hurts the brand value of the company, isn't it? In that case, how should I protect the goodwill of the company? Trademarks. Agree? Okay. So, in order to protect the goodwill of a company or a goodwill of a business, I file trademark. Okay. And if I want to protect the functioning of a device or an apparatus, I file patents. If I want to protect the way the product looks like, I file industrial design. Amazing. Okay. Then I am a storyteller and I write stories and I write poems and I compose music. I protect this through which form of IP? Copyright. Okay? The Thaikudam Bridge story comes here. Okay. Then there is something. Okay? I have found out something and that is groundbreaking. And if I, let's say, if I file it for a patent, after 20 years it comes to the public domain, which means anybody can use it. Okay? But I have found out something that nobody could ever figure out. In that case, what do? We go for trade secret, which means I'm not going to tell it to anybody. Okay? Next slide. This is one typical example and amazing story for different types of IPs in a single product, which is a Coke bottle. Okay? See, this is a unique design of a Coke bottle. Okay? That was filed in 2002. Okay? the cap opens in a particular manner. Okay, it was the first to introduce the slide opener. Okay, without a can opener, you are able to open the lid. Okay, this is a utility patent. This is a functionality, isn't it? Then the way bottle looks like, it's a design patent. And Coca-Cola is a well-known brand and there's goodwill associated with that. So it's a trademark. Okay. And how many of you are aware that the formula of Coca-Cola, only 2 people in the world know about it? Right? So they have not gone for a patent, right? If they had gone for a patent, which means after 20 years, anybody could produce Coke, correct? They will go out of business. So they decided, let's keep it a trade secret. Okay. And um, and Coca-Cola comes up with different marketing materials, right? All those marketing materials are copyright. Right. Okay. So we are sitting here with a lot of light, right? Which is man-made. Is it man-made or natural light? Man-made, right? So according to you, man-made light source is a ground-breaking or let's say game-changing invention? Yes or no? Fast. You say yes? Okay. Next slide. Okay. This is the way that the lighting system or the man-made light source evolved. Okay. So in 1780s, somebody figured out oil lamp could be used to light a room. Okay. Then in 1792, gas lamps were introduced. Please observe it carefully, right? We already had a solution. We already had a solution to overcome darkness. That was oil lamp. But oil lamp had a lot of risk, a lot of spillage, creating nuisance. And somebody figured out, let's create a gas lamp. And gas lamp again had some problems. Then Newton came up with, sorry, Newton or Edison? Who came up with Edison, right? Edison came up with the light bulb, right? And a lot of us, and whenever we go and study IP, we are taught that light bulb is a game-changing invention, correct? Newton patented it and utilized the technology for 20 years. Then it came to the public domain, which means the technology on which Edison had built the bulb on was a problem statement for future generation. And they came up with fluorescent lamp. Then after almost 70 years, okay, the fluorescent lamps were not found, not so efficient. Then they came up with LED lamps in 2010. See, this is how inventions evolve. Next slide, please. Okay. See, this is an innovation cycle that I came up with based on 5 years of experience and a lot of readings. Okay. We introduced something as new technology. Okay. We believe that this is groundbreaking. Okay. And after some time, a person finds out a problem in the technology, right? And he addresses that problem. Okay. Then it becomes again a new technology. And after some point, another person finds a problem with that new technology. Again, this cycle goes on and on and on. How many of you agree with this? This is how the world evolves, right? Yes, next slide. Okay. So what is our first learning? We should define the problem statement properly. So whatever is existing today and whatever pain points we find out in the existing technology is our problem statement. Agree? So every patent addresses a particular problem statement. Got it? Fine. So this is another very good example to understand how solutions are offered for different problem statements. Okay. So in the 1800s, that people figured out that tin cans are a way to preserve products and let's say transport products from one place to another. Okay. And they had figured out how to close the tin lids, okay, or the tin cans, but they didn't know how to open it. Can you make a guess how people were solving this problem of opening the lids? They were using gunpowder. Okay, that is the extreme way they had taken to open a tin can. Okay, then a person figured out, okay, this is a problem. Okay, I want to solve it. And he figured out a can opener. Okay. Then this can opener was not so much user friendly. Sometimes people used to cut their own fingers. Okay. Then they added this small pin you see. Okay. Now this becomes very easy to open. Self opener. Okay. This is how every solution finds a new problem and new problem finds a new solution. Got it? Fine. This is how you innovate. So what is the first step in innovation? Find the problem or the pain point. Agree? Fine. Um, according to you, what makes an invention wow? Some random guesses. Come on. I see some people sleeping, but that's okay. Even I used to sleep when I was in college. Yes. So come on. Take a random guess. What makes an invention wow? What should it do? Okay, one functionality. Thank you. Another one. To say wow. I mean, this is amazing. This is groundbreaking. Convenience. Amazing. One. Convenience is a good answer, but try to quantify it. Right? Convenience may change from person to person. I may be convenient sitting in the first bench, but those people are not convenient sitting in the first bench. Right? So, how do we quantify convenience? Okay, what makes an invention wow? One last guess, then I'll continue. Sorry? Low cost. Amazing. This is one. Okay, it should be affordable. Let's say that I created an invention, but unfortunately nobody can afford it. What's the point? Right? It should be affordable. These are some of the factors. I'll take you through point by point. Okay. So there are some requirements that are set up by different patent offices of different countries, and there are some observations that patent attorneys have seen. Okay, one is novelty. Novelty means not known to anybody. Okay, very simple. Have you seen a chair with 4 legs? Yes. Come on, answer. Yes. Yes, you have seen a chair with 4 legs. Have you seen a chair with 3 legs? Have you seen a chair with 2 legs? No, right? Have you seen a chair with 8 legs? No, which means it is novel. You have not seen. It doesn't exist. Correct? Okay. Next. No. Second point. If I could make a chair with 4 legs, can't I make a chair with 8 legs? What is the inventive step in that? There is no inventive step. It fails to satisfy that condition. Correct? Fine. So, essentials. First essential is it should be novel. Second essential is it should be inventive. Inventive means it should not be obvious to the inventor. That. Okay? You understand the obviousness? Which means if I can make a chair with 4 legs, I can also make a chair with 8 legs, right? Which is an obvious change. Okay. Next, it should have industrial applicability, which means I have made a chair with let's say 8 legs, and it should be mass producible. Okay. If I can make only one copy or one product of that particular invention, which fails to satisfy the industrial applicability requirement. Okay. Then this is very, very important point. This is what causes the point of differentiation with respect to our products, our invention, and all other inventions out there in the market. That is, it should be easy to license, or it should provide protection to your own product. Okay? Or it can also be said that that product you are building is marketable. Okay? I'll explain it. Okay? Let's say you're building a solution. Okay? Let's say you made a new type of a key, but you don't know which lock it opens. What's the point in that key? Correct? Whenever you're creating an invention, you should keep in mind that can this invention be directly applied to solve a problem, okay, that is existing in a particular industry, so that you have a solution, go there, say, I have made a solution which can solve this problem you're having for years. Okay? It should be in such a way that it should be easily licensable. Okay? Or let's say that you want to create a startup. Okay? You want to, let's say, make multiple copies of the product and sell it in Indian market. Okay? Then in that case, the invention that you have created should provide enough protection to your own product. Okay? And the product that you have created should fit the market. Okay? Let's say you made an invention and market is not accepting that, or the industry is not accepting that. Then what's the point? Okay? I understand this is a little bit difficult for you to comprehend. For that reason, I have taken some example. Okay. So here I have some well-known patents. Okay. Let's start with that train. Okay. Can anybody take a guess what train is that? Bullet train. Okay. On what principle bullet train travels? Is it electrical or magnetical? Magnetic levitation, isn't it? So they created a technology and they found out what application could be and they directly marketed it. Okay, that's an amazing patent. Okay. Next, we are seeing one phone here. Can you figure out which phone it is? iPhone, right? So they created a phone which has unique features and they said that it can solve multiple problems that is there with the consumer. Okay. Next, we are seeing something flying over there. What is that? A drone or unmanned aerial vehicle. Okay. Today, drones have replaced so many soldiers where it was threat for those soldiers to go there in the front lines of the battlefield or high altitude regions. Okay. So it's an amazing invention. And then you're seeing that it's a graphene. Okay. Graphene even got a Nobel Prize. Okay. Let's say that you figured out, let's say, fourth law of motion or fourth law of thermodynamics. Do you think you can patent it? The answer is no. Okay. If you figured out an application over that, then it is patentable. Okay. The mere discovery of graphene was not patentable. The application of graphene, how it can be used to increase the strength of reinforced, let's say, polymer materials. Okay. And that was patented and that was even a subject matter of a Nobel Prize. Okay. Then we see here, it's an exoskeleton. Okay. That helps people with lack of ability to walk. It helps them. Okay. It's an amazing invention, which means it is easily marketable. Let's say that the first three essentials, novelty, inventive step and industrial applicability are already there, and we should differentiate. It's the X factor. Okay. We should be able to differentiate whether those inventions are easily marketable, easily licensable, or does it give protection to our own products. This is the X factor that you need to think about. Okay. Next. So I have some more inventions. Okay. Do you think this is a good invention? A beer bottle with umbrella. Okay, somebody invented that. Okay. And next, that's a urinal, and that person is taking rest, head rest. Okay, in the urinal. Do you think it's a good invention? Does and for your information, it satisfied the first three conditions: novelty, inventive step, and industrial applicability. But it lacks the marketability. Marketability is not there in any textbook. Okay, this is what we patent attorneys have figured out. Okay, next, there is a new type of alarm. Okay, so let's say that there are people like me who do not want to get up early in the morning, and for them, our invention is made. Okay, it makes so much sound that you will have to run away from your bedroom. Okay, it's an invention. But have you ever seen these inventions coming into the market? Do you think the market will accept or adopt these inventions as a solution to their problems? No. Even though they satisfy the conditions, the criteria of a good patent, but the patentability requirements, but it fails to satisfy the fourth condition of marketability. Okay. So, one step back. One in there. So this is a statement that I keep on making. Okay. Patent, or for that matter, any intellectual property, is only a piece of paper unless it sees some revenue. Okay. Let's say to get an intellectual property, the organization or inventors or a startup puts so much money into it. Okay. And if there is nothing in return, what's the point? Whatever you get is a piece of paper as a validation to say that it compliances with the requirements of the IP Act. That's it. Okay. It's your duty to make sure that it is marketed properly and it brings some revenue. Got it? Fine. Next. Okay. Second learning is keep the solution relevant to essentials. Okay. Whenever you're building or creating a solution, you should keep these essentials in mind. Okay. Learning one, define the problem properly. Okay. Learning two, keep the solutions relevant to essentials. Okay. We saw that beer bottle with umbrella, right? He didn't even define the problem properly. That is why it was not accepted by the market. Correct? So whenever you define the problem, you should be very cautious. Okay. Next. Fine. Every inventor thinks his invention is going to change the world. Isn't it? How many of you agree? Right? So everyone thinks that their invention is something great. Okay. So when they come to us and they discuss their invention, so we keep discussing inventions day in and day out, and we would have heard something similar somewhere, right? So whenever we say that, okay, they get offended. Okay. So there is no point in reinventing the wheel. Okay. I believe, I have 100% faith that if you can come up with one particular idea, you can definitely improve that idea. Given that, you should know how to look for similar prior arts or similar arts that exist out there in the market. Okay. Next slide. And this is a free software or free website. Okay. It's a patent database. It's called Google Patents. Okay. And it allows you to access thousands of patent databases, or thousands of patents. Okay. So I wanted to understand, in the root canal crown, the crown that they place after root canal is done, what is the innovation going on. Okay. I just gave one small keyword and I could see 84,122 results. Okay. Which means we may say that we have figured out a new way of crown, but trust me, there will be one result or maybe more than one result in 84,122 results, which could be similar to yours. So you should analyze the field properly. Got it? Fine. Next. So learning 3. Patent is a technical document, so provide as many technical advantages as possible. So whenever you see what are the advantages of your invention, try to quantify it. Okay. If you say this is very easy to use, let's say for an experienced person, it is definitely easy to use. What about a person who is using it for the first time? Correct? So and if you say it is cheap, whenever you say it is cheap, okay, for Ambani everything is cheap. For me everything is costly. Okay. So whenever you define certain things, you try to put it in a quantifiable way with respect to technical advancements. Okay. So you always bring out what are the technical advantages that your invention is having. Okay. Next. Fine. I have some commonly asked questions or frequently asked questions, and I'm going to address that. Yes. So does patent filed means patent awarded? Okay. And I have a story that one client approached me and said that he has to file a patent, and I agreed and filed the patent. And after 2 days, he calls me, give me the certificate. Dude, I'm not an authority. I'm only a person who is representing you. Okay. Patent filed doesn't mean that patent awarded. Okay. You need to fight the prosecution phase. Filing a patent is just like filing a case in a court. Okay. Does that mean if you file the case in the court, you already won it? No. Correct? So, what's the probability of winning a court case? 50-50, right? Similarly, it goes with patent. Given that you draft the patent properly, the chances of patent getting accepted is high. Okay. So patent follows a patent timeline. Okay. So whenever your idea is in concept stage, as I was explaining that most of you are conceptualizing certain things. Okay. Whenever idea is in concept stage, we file something called provisional specification and we reserve the priority. Reserving a priority means very simple. Put a towel on the seat and say that I'm the first person to do it. Okay. Filing a provisional is as simple as that. Okay. Then you get maximum 12 months time to follow it up with a complete specification. In the complete specification, you give as much details as possible and make sure that it is in line with the product that goes out in the market. Okay. Then your application is published. Once the application is published, you will be able to access it and it is told to the entire world that you have come up with certain invention. Okay. Then you will have to face the prosecution or the examination. There will be usually 2 rounds of examination. Given that you defend both the rounds properly, then your patent is awarded. Usually in the expedited mode, it takes 1 to 1.5 years. In normal mode, it takes around 4 years. Okay. Let's say that if organization files 4 years, if individuals files or startup files, it is 1.5 years. Okay. Fine. Next. So provisional filed, not able to find on site, am I scammed? Okay. So this is also one of the commonly asked questions that people file the patent and they're not able to find it on Patent India website. Okay. Please note that the moment you file the patent as provisional, which is kept as confidential according to the law. Okay. Which means your idea is in progress. Okay. And do you want to tell it to the world that when your idea is in progress, No, right? Whenever a person has better equipments or access to better infrastructure, he might be able to develop it faster, right? For that matter, the idea is kept confidential until it is published. Okay, that's the reason you're not able to find it on Patent India website. Next, patent filed, but my name not shown. Okay, see, this is how an acknowledgement looks like. Okay, and it says an application number and title of the invention, and says to Pranav Bhat. One person even asked, I paid the money for you to file the patent, and you got the patent in your name. It doesn't mean like that. Okay, I'm the person who is communicating to the patent office, so it is addressed to me. Okay, so your name will be there, and it will be published once the application is published. Okay, next. I worked on the patent, my name is missed. What can I do? No problem. Let's say that multiple people contribute to a project at multiple phases, right? When the provisional was filed, that person might not be associated with the project. No problem. Name can be added at any point in time. Next. Somebody stole my invention. Come back. And filed the patent. What should I do? It usually happens, right? Whenever we come up with something cool, and it happened with one of my friend in engineering college. They discussed something, and his friend went to US and executed it. Okay. So in that case, what to do? Okay. It is not end of the world. There are provisions in law. You can file oppositions. Okay. Next. I filed complete specification. Now there are few changes. What should I do? Okay. So you filed complete specification, which means it cannot be changed anymore. But you have some changes. In that case, there are options. You can file a new complete specification or file a patent of addition, saying these are the improvements. Okay. Next. I have found out a new way of performing a treatment or a surgery. Okay. Or a way of counseling a patient. Is it patentable? Okay. Unfortunately, it is not patentable according to Patent Law of India. Okay. Fine. So in my past experience of 5 years, I have observed certain things. Okay. Given that you have a good IP portfolio, okay, let's take an example of Lightspeed AI Labs. They have zero sales. If you had seen Shark Tank, the first thing that sharks ask is sales kitna hai, correct? This is a typical case. They had zero sales, but they had a valuation of $2 million US. How? Because they had very strong portfolio of 16 patents filed across jurisdictions. Okay, this is the power of IP. And there is a company called Big Tech Labs. Okay, they created a technology, and they figured out one particular person copied it. They waited for 2 years, then they filed a case. Now they're aramse living on the royalty. Okay, so this is the strategy that people use. Okay, now, and patents or IP is also significant for the contribution of intellectual property or contribution to the area of research for multiple organizations. Okay, it directly impacts the NIRF ranking. Then my friend is there, Sanjay Kashyap. We did our engineering together. Then he applied for a university called Northeastern University in Boston, and he got free seat. You know why? Because he said, I'll help you in patent filings. Okay, only thing he does is he files one patent per, I think, 3 months, and his tuition fee of, I think, around 40 lakhs is waived off. Okay, he's only, and he's given, even that, he's given some research assistant scholarship for doing the research and filing the patent. Okay, this is how having knowledge in IP helps you, not only in India, whenever you go outside to study as well. Okay, that's all I had to present. Okay, so if you have any doubt on patents, or if you have any doubts on industrial design, I think most of you are coming up with certain devices which are subjected to patents and industrial design. And if you're coming up with certain different types of literature, then it is subject matter of copyright. If you have any questions in this case, please ask. Thank you, and that's my 30 minutes. Thank you so much. Any questions? Okay, thank you. Okay.
Hello, sir.
Yeah, yeah, sure.
So if there's a similarity between a product, but the features are not completely similar, then that can be patented, right?
Definitely, yes. If you have a new feature,
There's difference in functionality.
definitely, 100% yes, it can be patented. So the scope of the patent depends on how much difference you have. Got it?
Okay. Yeah.
Fine.
Thank you.
Yeah, sure. Yeah. Okay, sir. Fine. If you directly apply for a patent in UK, then patent office will give you a call and police will come and take you to US jail. Okay. So the way is first apply patent in India, wait for 6 weeks, then apply outside. Okay. So you have two options while applying outside. You can take the PCT route, which will give you priority for 31 months, or you can file for something called 12 months filing. Okay. Immediately after filing the provisional, within 12 months you can file for the international country whichever you are designated to. Okay. Or second route is you can inform the patent office that you are going to file a patent outside India and you are not interested in filing the patent in India. Then you will have to file something called Form 25. Take permission from that. It's called foreign filing license. Then you are free to file in any country. These are the two ways. Yes. Sure. Yeah. Any more questions with respect to copyright, industrial design, trade secret? So another thing we are observing is with respect to traditional knowledge. Okay, whenever we are speaking to the the doctors who perform certain sort of Ayurvedic treatment, okay, they don't tell the ingredients that they are choosing. Okay, it's because they are scared that people will take those things and create it into certain pharmaceutical products, which we have seen in Western Ghats quite often, and some of these the Ayurvedic doctors, they go there, they collect those herbs, and some pharmaceutical person try to befriend them and get to know what is that product. Then they convert it into a pharma product. Then they start selling it. So they don't share it to anybody. They keep it as trade secret. Got it? Yeah.
Thank you, sir. Now I request Dr. Nandineni Ramadevi, Director MSAP, to present the memento to Pranav Bhat. Ma'am, uh, thank you, ma'am. Thank you, sir.